When I first started doing this work, we spent a lot of time talking about the difference between alienation and estrangement, which is a very important conversation, but it wasn't a whole lot of what do we do about it? And of course, for those people working in this field, we know that we still are pulling our hair out going, what do we do about it? Because it's such a challenging field to work in. We're going to start out with a very brief discussion about attachment. Basically, we're talking about the emotional connection, the bond between parent and child, and the draw towards each other that keeps people together emotionally. From psychology, it's a way of helping us explain development and relationship. And from family law, it gives us a lens to kind of look at things and understand the parent-child relationship. It's basically essential for human survival. It's natural to be drawn to your caretaker. It's the way that the human race has survived. Children come into the world, they're completely dependent upon their parents, and the parents, oddly fall in love with them because they're so cute and they look like them or something. And then, we protect our children, and this is the natural way of things. So what we're looking at is we've got situations where attachment begets attachment. So if we have secure attachments and healthy attachments developing when we're young, the chances of us having secure attachments as an adult are much higher. And then we start dealing with the attachment disruptions. JP and I have kind of used this term for a variety of reasons. And one of the reasons has been, especially in regards to the courts, that we're looking to have an understanding of how we can get interventions in there quicker. And so sometimes, rather than spending all the money arguing whether it's estrangement or an alienation, we sort of have this belief that, hey, maybe if we just say, there's a disruption here, there's a problem here, let's get moving on an intervention, can make it easier to be supported by the courts and for the judges to order some interventions. In BC, judges can order interventions, they can order counseling.
Some of the Amy Baker research, she did some really interesting longitudinal work looking at people that self-identified as having been alienated as children. And apart from the ACE stuff that you see associated with that, these people had lower rates of independence, they had higher rates of relationship dissolution as adults, and there's this one particular Amy Baker study, had a very low end, something like 50 or something like that. And at the time of the study, half of the people in her study group were detached from their own children.
In our intake and our screening, almost all of them have some sort of disrupted experience or attachment with their own caregivers from their own childhood. So what we also have is the perfect storm. We have, the personality disorders or traits, and with some poor and misguided parenting, with the stress and hostility of a divorce. And what's interesting, that idea that a lot of people can function, or maybe it was Nick, they can function very well with their personality disorder and be quite functional parents and citizens of the world, etc. And then they go through this divorce and bang, it just sends them off. So basically the thing is, when there's parent-child contact problems, whatever the cause, whatever the issue, however you want to define it, we know it's a problem and it needs to be dealt with.
So the problem that I've experienced in my practice is that when you go to court, allegations about alienation are intrinsically polarizing. And then you throw that into the mix of the adversarial high conflict process of litigation, finger pointing becomes a necessity. The only rational explanation for the child's reluctance to visit has to be not me, because I don't want to engage in that difficult examination of my own parenting skills and the history of my involvement or lack thereof with the child. So because it's 2018 and I have access to the internet on any one of a handful of different devices, I Google this and I discover alienation. You can sit there right now and Google alienation, and the very first thing you're going to run into are a whole variety of websites, not the websites of psychologists and other mental health professionals, but websites that have been put together by people who have felt the sting of that narcissistic injury. However, the only reasonable response to "you're alienating" isn't, well, I alienated just a little bit. It's, no, you're a horrible parent. And of course, it makes sense because that's the bread and butter of custody disputes in high conflict families, is digging into the past and, well, there was that time you did this and you weren't there for this and you prioritized work and you're a drinker, you're an alcoholic, you use drugs, and all the rest of it. So you're in a situation where neither party can make any slightest concession. And of course, part of the problem we have is that we have non-specialist courts in so many parts of the country. And so the judge here before is more likely than not to have been a former prosecutor or a former corporate commercial lawyer than the judge is to be a family law lawyer. So 9 times out of 10, if not higher than that, you're dealing with a lay judge, at least in terms of this. So the reason why Alyson and I have glommed onto the idea of attachment disruption is that it's the bridge between estrangement and alienation. And my hope, naive though it probably is that the one thing parents should be able to agree on is the fact that the child is reluctant or resisting contact. At least you can agree on that. And if we characterize, I dare to suggest, the reluctance as attachment disruption, or some other word that means roughly the same thing, it should allow us to adopt a more neutral, more constructive approach to dealing with these highly polarizing, very difficult cases.
And that's where, having interventions that can respond back and report back to the court become really important, because in so many other types of law, it's what happened in the past. But in family law, it's what's happening right now. And when you get an intervention in there that can report back to the court, the judge can get more relevant and real-time information. So I think these are questions, especially around these interventions, that we need to ask, especially with attachment repairs and these issues, is, should reunification be the primary goal? Is that considered a success just if you've got people talking or spending some parenting time together? If it doesn't occur, is it a failure? We had one case. It was a 17-year-old boy, was ordered in. He was very enmeshed in a relationship with his dad. But he came into the program and he said, I hate my mom, she's terrible, I'm never gonna see her again in my life, I can't stand her, I don't want anything to do with her, I never need, the whole bit. And by the end of the program, he basically said, I don't know what the big fuss is. He said, I'm probably gonna go out for coffee with her in a few months. And so did we have reunification? Did it occur when the program was happening? No. Did he go out for coffee with her about 6 months later when he decided to? Yes. Right? Was that a success? Yes. Yeah. The easiest measure that we have, like I said, is the restoring the relationship, because that's clear. We know how to measure that. We can figure that one out. It just doesn't necessarily capture all of the goals of a program. There's been some programs that claimed up to 98% success rate. And I don't know, for me working in the field, I'm going, really? I don't know who you're working with, but they're not the same people, or I'm really bad at what I do, because I am not getting 98% success rates. If you're hitting 50, you're like a superstar. Like a superstar. If we're actually, and again, what are we measuring it as the success for? So the goals, achieving more balanced and ambivalent views, and trying to create some security in the attachment, and supporting the attachment. So it's the standard stuff. But I think the point is, I guess what I'm saying is just reunification isn't necessarily the end-all and be-all of this process, which is very hard for that rejected parent to understand when they come in. When I first started doing this work, you'd get these orders, like a judge might even order, go to see counseling, get counseling, and it's it becomes dangerous for so many reasons. It's quickly ordered because it's easier and it's cheaper. So if you bring in one therapist to work with the family, it's way, way cheaper, right? And if they're not, necessarily highly specialized, the prices per hour is going to be better too. And so it's true, right? And so it becomes the easier solution. So coordinated counseling would be more when we have a group of people that are trying to address this. So a community case program would be one where they're operating under the same goal, probably one treatment plan, one treatment agreement, ordered for one place. It'll often be a team. In our program, it'll be, we have 3 people on a team. I will be the director, and I usually report back to court. Sometimes, not always, sometimes it'll be the other team members, and we'll have a parent therapist and child therapist working with the family. Again, it's costly. It's not a cheap process, and it's not a quick turnaround. I say to clients, it took you a long time to get here. It's not gonna, you're not gonna be done this, and it's gonna take you a while for us to unpack these and work on these things. So with residential programs or more the camp-based programs and things like that, the idea of bringing in and having an intensive experience where there isn't a bunch of distractions, where there isn't a bunch of things, and you have highly skilled people doing the work. And sometimes that can really help move things along quicker. Again, they're costly. Some people think it's the magic cure, and then they're frustrated when it didn't magically work. And there still needs to be the follow-up treatment.
You want the trial judge to be the judge who's managing this program, to give you the kind of back support you need. If it's a different judge, even a judge who's willing to seize herself and manage the file into the indefinite future, it's still somebody who didn't hear the evidence at trial, wasn't able to gauge the honesty and the personality of the people who are giving evidence, and doesn't have the same insight into their personality and their predispositions. And you often need a situation where there is a reporting requirement in place, and if there isn't a reporting requirement in place, the next best thing may be to have a series of scheduled meetings on a fixed basis. The reason why we need the court involvement, the court to be involved, is to address non-compliance, right? So the therapeutic team who's reporting back to the court can provide progress reports. Expert testimony is needed. So having thought about these issues, Alyson and I sat down and we thought about what a court order would look like. And in the materials is a model court order. The first paragraph of the model court order is, the applicant will forthwith, or even better, use plain language, which this is not, the applicant will retain name of program to work towards the resolution of identified issues, identified parties, identified children, as defined by and on a timeline recommended by the name of the program. The next paragraph is that the parties will support the children, putting the positive onus on them to do that. The parties are restrained from taking actions or non-actions which may jeopardize the success of the program. The parties are required to sign releases, sureties, and other forms and documents that are required by the program. That's to make sure that you have their compliance and that you have the releases that may be necessary to speak to previous therapists, assessors, school people, and things like that. Paragraph 4, though, is the catch-all. It's that allows you to require them to produce any and other documents that you need. Paragraph 5 is another important one. The parties will follow the treatment recommendations of the program regarding parenting time or contact with the children, or and there's an alternative, or will follow the timeline prescribed by the program for the implementation of the parenting plan or contact arrangements ordered by the court. Paragraph 6 concerns general compliance. Paragraph 7, another important one, allows the name of the therapist or the clinical lead or the program director to contact the court, so that's a proactive ability to contact, to write a letter to the judge with respect to matters arising from the resolution of the issues and the treatment recommendations. Paragraph 8 talks about payment provisions. Paragraph 9 speaks about the ability to, again, report to the court and the ability to provide evidence on any aspect of the treatment. Paragraph 10 allows the therapists involved to communicate with third parties, the lawyers directly, as well as medical professionals, mental health professionals, social workers, and anybody else that's going on, so that you have the party's permission, and well, in this case, it's the order of the judge. Paragraph 11 discusses the fact that the process in this particular model is not going to be confidential, to allow the team members to speak to each other fully and frankly about the matters involved in the treatment and how things are protesting, and an explicit statement that these communications are not privileged and not subject to therapist-patient confidentiality. Paragraph 12 contemplates the idea that this is for a fixed period. It could be a renewable period. There's nothing wrong with that, but it seems to me that that the idea of a period meets a number of objectives. It gives the parties and the court something to look forward to. You're not promising that something is going to be accomplished by the end of the period, but it gives them a date to look forward to getting rid of you if they hate you. Plus, it gives you the ability to monitor your own process. If things aren't going well and these people are beginning to chafe you, It may be that they need to try somewhere else. Paragraph 13 is an injunction that restrains the parties from making complaints during the period in which they are involved in the program to governing bodies, so colleges of this, colleges of that, as well as consumer protection bureaus and any similar entity without leave of the court. The last paragraph of the proposed order is the all-important direction that the court seizes itself of any further applications involving this family relating to the issues about parenting. Now, I did mention that some of these programs have been springing up, and it seemed as if, at least a few years ago, it was like they were springing up like mushrooms in the forest after the rain, and before, my office was constantly being deluged with new pamphlets and new brochures advertising new programs. What you would see is that every time there was a meeting of the Family Law Bar Association, a handful of people would show up with a box full of brochures and hand them out, and I've got no problem with that. That's wonderful. Advertise your services. But it made me reflect on how well-equipped lawyers, never mind judges, might be to critically evaluate the programs when they're looking at these glossy four-color print flyers, especially the websites with theme music in the background of the sun coming up over the horizon.
And everybody holding hands.
That's right, yes. See, look, it works. And so as a result of that, the other document that you've got in your materials is an assessment checklist for reunification and reintegration programs.
We've been talking about, research and evaluation, and what we're looking for in this checklist was to sort of what should people be looking for in these programs. So examining credibility, like, is this a person that's known in the field? Do they have a background in this work? Have they been working in it? Doesn't mean everybody just magically becomes an expert in things. You have to earn your way and work through it. But are they recognized by their peers?
And of course, they also need to be insured lest the wheels fall off the bus while someone is underneath.
Is there experience?
And I should mention that the checklist is intended for a lay audience of lawyers and possibly a judge, and these are sort of things to think about rather than absolute yays or nays.
So are there reasonable goals? Are there outcomes named in the program? And is there a limited mandate? Because a judge really shouldn't be ordering somebody into something endless. Right? They shouldn't be. There should be some sort of time limit on it. Reporting to the court, as we've been talking, I can't say how important that has been in this process for me to be able to go back and go to the hearings or go to the case management and report back directly to the judge.
Red flags, we suggest not being a member of a recognized regulatory body. The people that aren't known are recognized among their peers, and then the success rates that are high. And then there's the programs that won't explain or discuss their methodology. This ought not be a black box. If you're a lawyer recommending this to the court, you have to know what they're proposing to do, how they're planning on handling bumps in the rug. If they won't discuss with you what they're doing, that should be a reason to stay away from it.
In the more organized programs, there's going to be a process that they have to go through and documentation that shows that they've gone through it. So the screening isn't just I had a session and we talked about it, right? There's something that's a record that you have shown that you've screened.
And that last point comes from the paper I was reading. When I was reading all those cases, it was astonishing the number of times a custody assessment had been prepared in which the assessor recommends his own program, which strikes me as just a smidgen of a conflict of interest, but you never know.
Yeah.
But that kind of obvious conflict of interest should also send up a red flag.
Yes. Look at that. Perfect. Okay.